you again for tuning into today's webinar. I'm going to hand everything over today to our moderator, Lindsay Reyes. She's our business development manager for the Miami-Dade region. And then with us today, we also have myself. I'm the business developer for West Palm Beach. And then we have Mr. Jerry Esposito, who is our business developer for Broward County. So Lindsay, take it away. It's all yours.
Thank you, Eric. Thank you so much for all the participants joining us today to talk about Senate Bill 4D. My name is Lindsay Reyes. I am Castle Group's Business Development Manager for the Miami-Dade region. I am joined today with my counterparts, Eric Malloy, who you just heard speaking. He is Business Development for Palm Beach, and Jerry Esposito, who is Business Development with Castle Group for Broward County. We're excited today to have Avi Trison and Jamie Gelfand join us as our panelists to dive into the subject matter. Avi is an attorney. He specializes in condo and HOA law. He is with the law firm Goa DeVos Cross PLLC. He's a managing partner there. And we have Jamie Gelfand, PCAM from Truist Bank. She is a senior vice president, so she'll be talking about the reserves portion and financing as it relates to what's going on in the community regarding Senate Bill 4D. So without further ado, I'll pass this on to Avi. As Eric said, please submit all your questions. If you do have a question in the interim as we are speaking, please feel free to submit it at the time. We'll try to weave some in. If not, we will do our best to get them at the end. So here we go. Avi. Oh,
you're on mute, Avi. Left myself on mute because it's raining around me also, but I don't have that luxury because I'm talking. Good afternoon, everybody. It's a pleasure to put on this presentation. The first thing I wanted to go over is this is one of the most significant pieces of legislation in the world of condominium and homeowner association law, and really focusing on condominiums that I've been a part of, and I've been doing this for a little over 15 years. It clearly is a reaction to what happened at Surfside, and that was an awful tragedy. What this bill did and what it was put together, there was a lot of talk, a lot of potential proposals and legislation that was supposed to have been brought to the forefront and voted on by March of last year during the regular session, and that didn't happen. The various bills failed for various reasons. A special session was called in May by the governor, and this bill, Senate Bill 4D, is what was put together, agreed upon by both houses, voted and approved, and sent to the governor for his approval and signature. And that is how this came to be. Like many pieces of legislation that can become landmark or are landmark pieces of legislation, when they're passed with the speed that this was passed, there are a lot of unintended consequences of what happened. Not that this is the same as Obamacare necessarily, but when Obamacare happened and was passed, it completely revamped our healthcare system. And there were clearly some deficiencies that needed to be addressed, and they were addressed over time, and perhaps some still need to be addressed now. But similarly here, there are a lot of unintended consequences that, in my opinion, and a lot of my colleagues' opinions, will have disastrous effects on associations, particularly with the financial components of what's needed in order to comply with the requirements that are in the statute. And so I'm going to go through all of this. As I've given you that speech, I've given this speech before. It is expected through my colleagues. And when I say my colleagues, I don't necessarily mean only the attorneys in my firm. I mean the attorneys that practice in condominium and homeowner association law. There's a listserv that is active throughout the state with hundreds of lawyers. And this is the general topics that we talk about, this being one of the ones that dominated our listserv over the past several weeks and months. Primarily, we believe that there will be a glitch bill that comes out in the next legislative session. And a glitch bill will and is designed to fix or correct certain things that are in an existing statute, whether it's something like this that had sweeping reforms or something that just needed to be tweaked here and there to have the intended consequences or intended intentions of the statute that was passed be more refined to particularly target what was the intended goal. So we expect a lot of these things to change. And in that context, I'm going to go over the bulk of what the statute says. There are some parts of the statute I'm not necessarily going into the minutia today, mostly because we don't have an extended period of time. Frankly, I usually do this in about 2 hours, so we're squeezing this a little bit down, but it's more what we believe to your benefit so you can understand the general scope of the bill that most likely will stay in, and then we'll see what the tweaks are come next spring. And so with that, I will begin with the presentation. And the first question is, who does this affect as far as condominiums are concerned? And it's any condominium that has one or more buildings that are at least 3 stories or more in height. Now, something that's important for you guys to understand, that was a debate for a while, but has now been pretty much understood. If you have a garage as your first floor of your building, that first floor, and you have 2 residential stories on top of that 3-story building, that first floor is going to count. So whether it's retail or whether it's a garage, that first floor will count as towards the total of 3 stories or more, whether you fall into the governance of this statute. Now, milestone inspections, which is the first stage of what we're going to talk about, they will be either required 30 years from the date that the certificate of occupancy for your building has been issued, or 25 years from the certificate of occupancy from when it was issued for your building, if your building is located within 3 miles of a coastline. Now, the definition of coastline is not necessarily clear at this moment in time. It's stated what it is in the statute, but it's not clear exactly what it means. What we've been advising the associations and clients and presentations that we've been giving is that the coastline is basically the mean watermark from whether you're on the Atlantic side or whether you're on the Gulf side, depending on which side of the state you happen to be on. Note that if your certificate of occupancy was issued before 1992, then your initial milestone inspection must be completed before December 31st, 2024, regardless. After the milestone inspection date, all condominiums and cooperatives, and something I didn't mention, almost everything that I'm about to talk about or have spoken about already applies to cooperatives if you do happen to live in a co-op or your building is a co-op. But I will routinely just say the word condominium because that's kind of how we're structured, because there aren't that many co-ops in South Florida. But they will be required to have the same inspection once every 10 years after the date in which they've had their inspection. Note that the statute specifically excludes single family, 2-family, and 3-family dwellings that are 3 or fewer habitable stories above ground. So if you have a 4-plex and up and it's 3 stories or more, then you will have to get, you will fall under the requirements of the statute. Now, what is a milestone inspection? What you have to do. The structural integrity inspections conducted by a licensed architect or engineer of a building, including load-bearing walls and primary structural members and systems. Now, they put licensed architects or engineers, and it's interesting to us, and by us, I mean my colleagues, because architects are not necessarily trained and designed in, once the building has been constructed, going through and being the one to do these types of inspections. So we are recommending our clients to get engineers to be the one to do these types of inspections because they're more specialized in this area. What is that causing, and what will that cause, and what we forecast this to cause as a problem going forward is, with the time limitations that there are to get the milestone inspections done and the number of structural engineers that are around that can give these type of opinions and do these type of reports, there's going to be a rubber meeting the road of not having enough engineers versus the amount, and architects, if you're going to have one, in order to get the necessary reports done in the timely manner. So we'll kind of see how that plays out, whether there will be automatic extensions if the association is trying but can't find someone to do the inspections, so they're not out of line with what the statute requires. The inspections must attest to the life safety and adequacy of the structural components of the building. Note that the local enforcement agencies are going to be required to send the notices out to the association when their inspections are due, and the associations will have 180 days to complete the inspection phase one, excuse me, of the inspection once they've received that notice. One thing that I do want to mention, it's not an inspection to see whether the building is in compliance with the Florida Building Code. It is only to do a structural inspection of the building to make sure that it's not going to be in danger of potentially falling apart or having obviously a situation that happened in Surfside. If the building fails the phase one inspection, and the phase one inspection is obviously more of that look around, making sure that there aren't anything that the inspector would see that could cause some more significant damage, or that there is not more significant damage present, then the phase two inspection of the milestone inspection must be completed. And the phase two is much more involved and is at the discretion of the inspector. So they can do invasive testing, they can drill bore samplings into the soil, they can do drilling into the concrete. They are required to, what am I thinking of? They are required to do the least invasive testing and least disruptive testing while doing their phase two testing, but they are required to do more substantial testing to make sure that there aren't any substantial structural deterioration found in that phase two testing that might cause for a problem for the association or the structure of the building later on down the line. It also serves as a function for determining how to assess and repair any distressed and damaged portions of the building, because that obviously is a concern where they just point out, well, you have these three things. Well, how do we fix those things? What do we need to do? So that's part of what they did, or what is required for them to perform. Now, this is where I would like to have Jamie chime in a little bit, because once the phase one report is done, and if necessary, the phase two inspection is done, I'll talk about what's on this slide momentarily as far as what needs to be done with the report. But if there is a phase two and work, repairs, maintenance, etc., is necessary, then the association has 365 days to begin performing that work that is necessary to fix what is noted on the report. And so, Jamie, what I wanted to have you discuss is how the association might be able to pay for those projects that they will need to complete in order to become in compliance with the failure in the report.
Hi, good afternoon, everybody. I'm Jamie Gelfand. I'm the Relationship Market Manager at Truist. Each of your associations work with your own financial institutions, and I encourage you to reach out to them at an early stage in this process to find out how to begin the loan approval process. You're going to want to reach out, get a term sheet, get some guidance of how much of a loan does your association qualify for. Financial institutions look at loans differently for associations, but the majority of them are risk rating that loan based on the number of units in the community, the house value of each of the units, what does the accounts receivable look like, and what is the annual budget. That risk rating calculation really determines that payment shock value to the owner. So when you're starting all of these projects, all of this needs to be taken into consideration. The beginning process is obviously with your attorney of what is authorized under the declaration for work to be performed, what are the requirements of the association, and then reaching out to your financial institution to determine whether you would be best served by a line of credit or a term loan. Back to you, Abby.
Thank you, Jamie. Lindsay, if you could go back one slide. Yes, one thing that I wanted to highlight on top of what Jamie said is every association has different thresholds for being able to approve a loan and get a loan through a financial institution. There are typical things that we see, and there are statutory requirements if the declaration is silent and doesn't address it. But it is something that we recommend you to speak to your association's counsel if you haven't already done so, or you haven't had experience before with obtaining a loan, because that you will need to do. The bank will require your attorney to most likely give an attorney opinion letter, which means that the association went through the proper channels to get that loan and obtain that loan. And you will also need to make sure that the association calls the meeting, whether it's for the board or whether it's for the members, whatever the steps are that need to be done in order to follow through with that process, so that you don't have a procedural issue later on down the line as you're trying to fund that loan and get the money to the contractors that are needed to perform those repairs. The other thing that I wanted to go back in here is to talk about what happens with the report. And first, if a phase 1 is clean, then there is no phase 2 required. And that's obviously maybe common sense, but I wanted to state that. Once that both reports, if you need both reports or it's just the phase 1, in either case, the inspector will submit the report to the association, and they will also submit the report to the local jurisdiction. Once the association gets the report, it has to distribute the report by mail, by certified mail return receipt requested, by email for any owners who have signed up to receive electronic notices. Regardless of the findings in the report, they must also post the report on the association's website if the association is required to have a website under the Act. And they also have to post the report in the association's common areas to make sure that people have access to do that. If the association fails to complete the milestone inspection, and for those of you who are board members attending this seminar, that failure is a breach of your fiduciary relationship with the unit owners. That could subject you to a lawsuit from the owners. That could subject you to a complaint filed with the DBPR, which is the Department of Business and Professional Regulation. And that is something that clearly you want to avoid. So make sure that you are in compliance. I just wanted to list a couple things that the report must have. Just so you're aware, it has to have the signature and seal of the licensed engineer or architect who performed the inspection. It must indicate the manner and type of inspection for forming the basis of the inspection, and identify any substantial structural deterioration, which is the key in determining whether the building is structurally sound. And then has to obviously state whether there's any unsafe or dangerous conditions, and recommend any remedial or preventive repair for any items that are damaged but not substantially structural deterioration state. Those are the things in association with the reports, and the reporting component of it is going to be both challenging and in a way it takes the gray area out. So there's a black and white, you're either performing the reports or you're not. And so just make sure you are in line with keeping up with those deadlines. Now, there is a structural changes to the reserves, and there is the creation of the Structural Integrity Reserve Study, which for short, the acronym is STIRS, which is fun to say. A study of the reserve funds is required for future major repairs and replacement of the common elements based on a visual inspection performed by the licensed architect or engineer. Your initial studies, no matter how old your building is, the initial studies must be completed by December 31st, 2024, and they're required every 10 years thereafter. So your budgets for this year, your budgets for next year, and your budgets for 2024 do not necessarily have to have the STIRS requirements as far as your reserves. But starting in January 1st, 2025, you will need to fully fund your structural integrity reserve study, your structural integrity reserves. So you must identify the remaining useful life and estimated replacement costs of the deferred maintenance and provide a recommended annual reserve amount that achieves the estimated replacement cost or a deferred maintenance expense by the end of the estimated remaining useful life of each component. Now, similar to the inspections with the reserves, if the association doesn't do the reserve study, that failure is also a breach of the officer and director's fiduciary duty to the association. And this is going to be key, and we'll go to the next slide if you could, because they dovetail with each other. So this is one of the big issues that most attorneys, most of my colleagues have with the CSRS, what has to be reserved. All of the items on this list come January 1st, 2025, have to be reserved in full. There will be no longer any waiving of any reserves and no longer any partially funding the reserves. You will have to fund them in full. Some of these kind of make sense. Some of them don't make any sense at all. I've highlighted load-bearing walls or other primary structural members and foundation. I've never heard of, and my colleagues, to their credit, have never heard of a foundation being replaced in a building. And the comment, generally speaking, that we've gone back and forth with is, how would you even go about replacing a foundation? The foundation is laid for the purpose of lasting for the useful life of the building. And when the foundation is ready to go, the building has lived out its useful life. There's only so much lipstick you can put on the pig, for lack of better words, in order to keep that building alive forever. It wasn't originally designed to last forever. It was designed to last for a set or a general number of years. And so this is one of the things that the associations are having a hard time with, particularly for you as owners and you as members of your association. Forget being board members. Are you going to be, does it make sense for you to pay for a 99-year item? If a foundation is a 99-year item or a load-bearing wall is a 99-year item for a place that at most you're going to live there 10, 20, 30, maybe 40 years in your condominium. And so it doesn't seem to make sense in the practical world. And so that's something that we expect to change. The other thing is, there's arguments and conversation over, is the roof something that's structural? It's not necessarily structural, and one can argue that it is, but it's something that keeps the elements out of the building and keeps the building protected from the elements. And so is it necessarily structural that the association should have the ability to waive the reserves for the roof or partially fund the reserves for the roof like they've been doing over the last years, since the inception? And so some of these things are just in question. And one of the questions that comes up routinely when I'm running this seminar is with windows. Some of your documents will have the windows are the responsibility of the unit owner to maintain, and the unit owner to pay for, and the unit owner to replace, and the unit owner to repair. And so now that is a requirement for the association to fully fund in your reserve account, in your CSRS reserve account, the question is, who's supposed to pay for it? And so this is something we expect to change, but for right now, the strict reading of the statute, the association would need to and will need to reserve for that item, even though it might not be something that they're responsible to pay for.
Avi, one of the questions that I've been getting asked a lot from board members and property managers is, can we take out a line of credit to satisfy these reserve dollars that are required in 2025? And from what I understand of the law, and you can clarify, please, the reserve dollars must actually be sitting in a bank account of the association, that just access to a line of credit does not, in fact, satisfy the statute requirement.
That is correct. The only way financing could help any association is if they somehow convinced a bank to fund future reserve payments. I'm not sure any bank would necessarily want to do that. And just to put clarity behind that or context behind that, and Jamie, please chime in, banks want to loan to projects that are ongoing, projects that are recently completed, tangible things, when it to loan based on future reserve payments, those are non-tangible things that an institution would have a hard time necessarily underwriting that type of loan.
So to repay a loan, there has to be the proper cash flow through either budget or special assessment to repay a loan. And in the instance where your association is being obligated to collect reserves to bring you up to 100% funding when you haven't funded before, that cash flow of repayment to a financial institution just doesn't make sense to a bank at this time, because you're increasing the debt of the association, you're increasing the assessments due by the owners, and by repaying the bank, you're not keeping those monies left into the bank account. So for example, if you had a $100,000 component that needed to be reserved for, and you haven't reserved anything for it, in 2025, my understanding is that you would have to start, and it had a 10-year useful life. My understanding is that in 2021, you would have to start reserving at $50,000 for that component. So you're exponentially increasing the assessments of those residents, and borrowing money to put into the bank account doesn't give you that cash flow of repayment.
Thank you, Jamie. One thing also that is a option for associations now with respect to their reserves is the concept of pooling their reserves. And just in case anybody doesn't know what pooling reserves is, you generally start out with straight line reserves. So if you, my hand might disappear with my background, but you start out with, you have your roof reserves, you have your painting reserves, you have your surface repair for the parking lot, and then you have any item that's $10,000 or more. Those are the statutory reserves that you have to have in the condominium association. And if you want, you can either keep what is statutorily given to you, which is you have the roof reserve, you have $2 million in your account. When the roof goes, you have $2 million to use. But if the roof goes and you only have $20,000 to use, but you have $2 million in the other accounts collectively, you would not be able to access that money without having a vote of the membership to reallocate and repurpose the money that's sitting in the reserve account to pay for that roof repair. Conversely, if you have pooled reserves, it means that you can use all of the money that is in the reserve account for any purpose that is itemized in the reserve fund. So if you have a roof issue, you can use the roof money, the painting money, and the resurfacing money to pay for the roofing issue, so that you don't have to get a loan, or at least maybe you'll get a loan later, but you have that immediate money, immediate cash flow to pay the contractors to deal with whatever that roof problem is. And, you know, kind of getting into more weeds than I should possibly, but you could eventually at a later point get a loan from Jamie to then fund that roof project that you did. But the concept is being able to have money on hand to pay for reserve items by using that pooled method. It just acts as one big savings account. Once the SERS becomes law, not that it becomes law, but once it becomes in effect, the concept of pooling reserves for these items that are listed on the slide that you're looking at will no longer be in effect. You won't have that possibility anymore. They will all be separate from each other. And so that will make it more difficult for associations to make their money fungible and have their money useful if the roof happens to go get damaged in the form of a hurricane that comes through, and they need to use the money to pay for that hurricane damage. They won't have that flexibility, unfortunately.
And that line of credit would be available to associations to fund their hurricane deductible cash flow issues. That's the perfect example of what a line of credit in place would be used for.
And then the last thing on this slide, we've routinely gotten the question if, you know, we had a reserve study done in 2020 or 2019 or 2021, or even this year, Is that going to be satisfactory for what was passed in the statute? And the answer is no. You're going to have to get a new one, and it's going to need to be done for the 2024 requirements. So even if you've had one recently, just know that you will unfortunately have to go through that expense all over again. So the proposed annual budget must include the most recent structural integrity reserve study as prepared by the inspector, and that will be part of what is mailed out from the board to the members as part of your annual mailing of the budget. And effective December 31st, 2024, the members of the Unit Owner Controlled Association, as opposed to Developer Controlled Association, cannot waive or provide for the funding of reducing of reserves that required for the structural integrity reserve study, which is what I mentioned. Now, the one interesting thing happened, which I don't know if it's going to change or not with this statute, because developers have a very strong lobby, as you can imagine, in Tallahassee. You may or may not have heard of the concept of deficit funding. And when developers are constructing a project, they will deficit fund, which means they are only funding the bills that need to be paid during the period of time in which they're constructing the project. And it usually is a period of 2 years after the date that they first close the first unit or get their CO. So the reason why this is a particular drastic change, and the change is that the developer can no longer deficit fund. They have to fully fund the reserves just as if the association would from day one. And this significantly is a huge change because it doesn't put the association behind the 8 ball day one when you take over from the developer. You're fully funded up to that date as far as what the developer's responsibility is for that financial burden, which is a huge shift. And that may or may not change depending on how much they've lobbied that to try and get it out. But for now, that is in. Additionally, the developer must turn over and must complete a structural integrity reserve study and their own milestone inspection to the association at the time that they turn over all documents over to the association. So these are new components that the developers require to complete. In theory, the reserve study and milestone study won't, the reserve study will be useful, but the milestone study won't be much of anything because you're talking about new construction. But the developer paying for their share of the reserves and turning over the reserve study will be very helpful and beneficial to the association. Now there are official records, and there are more things that need to be kept in official records. They changed the statute a couple of years ago to throw more things at the association's feet to be responsible for with respect to what are you going to maintain in your official records. The structural integrity reserve studies are an official record and must be maintained at least 15 years after the study is complete. A copy of the association's milestone report and all subsequent reports of the same nature, which are 10-year reports, and any other inspection report relating to the structural or life safety inspection of the association property are all official records and must be maintained for at least 15 years after the study is complete. An interesting change is that renters are entitled to inspect and copy the declaration, bylaws, rules, and all of these inspection reports. Additionally, all of these reports are to be made available from the seller to a buyer when a condo unit is being sold. And if these reports don't exist, the seller needs to make an affirmative statement to the buyer that the inspection reports are not available. I do a lot of transactional work as well as representing condominiums and homeowner associations. The Florida Association of Realtors and the Florida Bar have not come up with an amendment or an addendum to the contract that addresses this, but my expectation is that they will come up with something relatively shortly as this statute gets rolled out and the requirements go through their first, what we call the glitch bill. If the association has more than 150 units, it is required to maintain a website. The inspection reports, including any reports relating to structural or life safety inspections, must be posted. And the association's most recently reserved study must also be posted on the website. These things make it easier for a lot of questions that property managers will get. Can you get me the report? I want to see the report. Or buyers that are coming in and they want to see it, and the sellers ask, well, where do I find it? I don't even know where to look for it. So it is a benefit to make it easier for the community to have access to it. And so that is an additional requirement that was included in the statute.
I'm going to make one comment before you open into the Q&A. Every vendor that operates in the association world recognizes that this is a tremendous financial burden to associations, and that everyone is very hopeful that these glitch bills will put some sanity into the equation. So I would recommend that as an association, you reach out to CAI, Community Association Institute, a national organization that has legislative lobbyists. Travis Moore is our local lobbyist, and he certainly is very supportive of condominiums and cooperatives. And we all need to be able to band together to get these glitch bills passed in order to make this bill that we know is going to live in perpetuity, but make it at sane levels that we don't bankrupt associations and we can all get this work done appropriately.
Thank
I
you.
see a question that popped in for our wonderful panel. One of them says, should an association start looking for an engineer before receiving an official notice of compliance?
My first suggestion would be to wait and see what happens in March. And that's when the voting takes place, unless there's a special session. That's when the voting takes place on legislation. And so you can look for an engineer. The requirements for the inspection, I don't believe will change. Of course, that's obviously a guess, so you can take that with a grain of salt. So you can meet with an engineer, but if any of the requirements change and you have the engineer do their inspection, then that may invalidate your inspection. So you may want to wait for that. The notice that you will receive from the governmental entity, which I have a feeling, just based on how governments work, they may or may not be proficient in making that happen in a timely manner for when your building has in fact hit your 30 or your 25-year mark, depending on which you fit into. If you know when your building CO was, then you can do the math and you can say, okay, well, our 30 years was up, 10 years ago, or your building was a 1991 building, so you're going to have to get your engineering study done now. Then it is something that you could certainly start interviewing engineering companies and ask them for proposals in order to do this type of work.
And just to jump on that too, so if a change was voted on and changed, what's the time limit or grace period for the boards and associations to actually have to enact the change? What's their time there before it's mandatory?
Before the inspection is mandatory?
Yes.
The inspection is mandatory now. It's just a question of when it will be due for your particular community.
Okay.
And so it's going to be governed based on when your CO is issued, or if you are a 1992 or earlier building, then you're due now, or before December 31st, 2024.
I see another one in regards to what's considered structural. So plumbing, electrical, are those items considered structural? If so, why?
That's a great question, and that's one of the ones that we have. I don't believe that plumbing or electric is structural. I just, from a common sense definition, it doesn't seem to make sense. And that's one of the things that we hope that gets pulled out And that's one of the problems with that huge list. And if you want to go back to whatever that list is, Lindsay, so people can see it again, every item on that list is tacking on dollars that you guys have to pay every month to fund these reserves. And so if electrical systems and plumbing are taken out, that's money that you don't have to pay for funding those items that, the plumbing may or may not burst. So I'm not sure how that's going to come down. If that's going to be something, if those two items, for example, would be removed from this. Maybe they'll be moved to regular reserves where those reserves can be voted by the membership to be either waived or partially funded, and that becomes a different conversation to have. I'm not sure, but yeah, that's one of the questions that's been on my side of the table since the bill passed.
I'm sure. Not to leave Jamie out, we have some questions on the banking side as well. So one says, do we have to be up to date with reserves as of January 1st, 2025, or can we budget so that when the date is up, that we're fully budgeted at that point?
So I'm going to refer you back to your accountant and whoever did your reserve study for that complete answer. But from my understanding, in the year 2025, you have to fully fund for your components exceeding $10,000. Correct, Avi?
Yeah, everything that's on this list, and this is the $10,000 language is very vague. It says that any cost that exceeds $10,000 and the failure to replace or maintain such item negatively affects the items listed above. And that can be interpreted to include a lot of items. And so that's one thing that we are looking at. But yes, come January 1st, 2025, you will need to fully fund, however this ends up at the end of the day, you will need to fully fund your the reserves or be on a schedule to fully fund them, unless for some reason they push that date out or somehow make it a waterfall cascade where it's not fully funded the first year, but 50% funded the first year and 75% the first year and 100% the third year, something like that.
And then in 2023, can a condo still fully waive or waive the fully funding reserve?
Yes, up until the end of 2024, associations can fully waive or completely waive or partially waive their assessments, their reserves, excuse me.
What are some of the other questions you guys both get from boards? Maybe ones that weren't asked today, but that are just very common. I'm sure I know you covered most of them in the presentation, but I just was curious to know, what is the typical questions that you always get?
I'll say one that's comically and sarcastically, but do I know any developers that can buy their building? How do we get in touch with developers to buy our building? When I listen to you give me this presentation, it seems like my only option is to sell my unit before all of these draconian costs come crashing down on my head. Does it even worth it to live in a condominium anymore? Why should I be here? And I'm, all these questions, and they're valid fears. And it's something that, I represent a lot of buildings that call it, 50 units to 150 units of 250,000 to 600,000 value of this portion where they're of an older building. They're going to have to do special assessments, or the reserves are going to be significantly impacted and increased because of they're big enough to be big enough, but they're small enough to where it's going to be very significantly impact the owners, as opposed to being able to stretch it over a 400 unit building, and that makes it less burdensome on a per unit basis. And so that's, I've said it throughout this presentation of, we're hoping that a bunch of the things that are in here will be modified so that it's not so much of a situation for the owners where really some of them, their only option is to either sell their unit and get out because they don't want to deal with this, or the building needs to be sold because they're going to go bankrupt because they're not going to be able to afford this. And I've been approached by, I said it sarcastically in the beginning, but I have been approached by several condominiums that I represent that they don't even want to wait to find out what the bill is modified to be. They want to find developers and they would just want to figure out a way that, the owners just don't want to deal with it. The building's too old. They already were dealing with code violations with the city. They already were working on special assessments in the millions of dollars, and they just didn't want to take on well, we haven't spent the millions of dollars yet. Why don't we just find a developer, get millions of dollars and get out of the project? And so that's one of the biggest takeaways for me for this. And I have said, I'm not the first one to say tragedy plus time equals comedy. That's routinely said. In this instance, you have tragedy plus, this isn't a tragedy of a statute, but it can be very difficult for particular associations to have to abide by the requirements.
And because of the increase of condominiums considering abandoning the condominium and selling to a developer, from a financial institution, we've changed our language to say that should that occur and you have an existing loan with the bank, that loan must be paid off, even though it may have had 10 years left on it. That loan obligation is still a rightful debt of the association. One of the questions that I've overheard being asked a lot is what does the attorney recommend when these statute requirements are in direct violation of the declaration of the association? So for example, if they could only raise their reserves X percentage and the statute is now requiring fully funded, they're in conflict of their own declaration. How is the attorney handling that?
It's a very interesting question, and there's a legal concept called an impairment of contracts, meaning the owners and the association had an agreement and a contract of this is what I'm going to pay, and if you can special assess me, but it can't be more than 115% from the year before, and some other concepts that are actually mimicked in the statute or just for that particular association. What will end up happening and what ends up happening is the statute will control, and in this instance, it will control, and it is not something that the declaration will be able to override what is in the amendments to the act and the statute in this instance. In certain instances, the association's documents will control, but this is not going to be one of the ones that if a homeowner wanted to take this up to the Supreme Court, whether of Florida or of the federal Supreme Court, it is not something that I can't imagine it would be ruled in that owner's favor.
So would the association's attorney write some type of opinion letter giving the association the right to proceed? How would that?
Yeah, that's typically for the board to have a CYA on their own actions. They can request the attorney to write an opinion letter, and in theory, if that opinion was wrong, then the lawyer would obviously be on the hook for giving the wrong opinion. But that's what lawyers are for, and the board, you guys are volunteer human beings that may or may not have some sort of expertise in the world of association matters, whether it's being a lawyer, or being a CPA, or some other profession, or you're a property manager. But even if you are one of those, you should rely on your attorney and not act outside of the scope of your role as a director or board member for your association.
We have time for another question or two to get us all wrapped up here right before 1 o'clock. And I see one here from Raul. Raul asks, can all other reserves be converted into pooled reserves? If so, how?
Yes, anything that's not let's just assume for the sake of argument that nothing changes in the statute from now until the end of time. There are reserves that don't fall into the SERS section. And so those items can all be put into a pooled reserve component. And that would be done just by a resolution of the board at a duly noticed board meeting, meaning the board would post notice at least 48 hours prior to that meeting and have a resolution, a motion made by one board member that says, I make a motion to pool all reserves, second motion by another board member, and the board would vote on it, and then the reserves would then be pooled.
When you referred to windows earlier, and this is a question from Jeff, does it mean all units have to have hurricane impact windows as opposed to just regular windows?
So there is no statutory requirement that all windows be hurricane impact windows. However, there is a mechanism for the association to require hurricane impact windows or hurricane impact measurements, such as shutters, if not necessarily windows, because windows are obviously more expensive than shutters. And so that can be part of what the association requires. And sorry, I don't know if I necessarily answered that question, but
we have one or two more minutes here, and I have another funding question from Kate, and she's giving examples. So say a roof is good for 10 or more years. Can we partially fund up until the 10-year mark? And then when will we have enough monies in reserves to replace the roof?
Sure. So the concept is fully funded doesn't mean that on January 1st, 2025, if it costs $3 million to replace your roof, you need $3 million on January 1st, 2025. What that means is you will, if the roof has a 10-year remaining life, it's $300,000 a year if my math is decent. So that means every year you will need to reserve $300,000 and collect that from the owners so that when you get to that 10-year mark, you will have $3 million in your hand to then go ahead and pay to replace the roof.
Gotcha. Well, I think we could end it here, unless Jamie and Avi, do you want to add anything as a closing statement, so to speak, before we say official goodbyes?
I would just like to say, make sure you are in constant communication with your attorney over this statute and what the changes hopefully will be in March and next year, because they directly impact you as a board member. You have fiduciary responsibilities. You now have a specific hammer that can come down on you in two places in the statute with respect to getting the milestone inspection done and with respect to getting the reserve study done. And so this is a landmark legislation. These are things that are very important for you to understand. And I went over some of the information here. There are certainly more aspects to the statute that I didn't go over today based on the limitation of time. And it's something you guys should understand more of as time goes on over the next couple months until we get to the next session, to make sure you're aware of what your responsibilities are and what the association's responsibilities are.
And I would just want to add that this is the perfect time to bring in all of your professionals of your association, your management company, your attorney, your accountant, your financial person, and sit down and really have in-depth conversations about what does the financial picture of your association look like today, and what is it then going to need to look like in 2025, and what is the strategic plan to get there.
Great. Well, I think that's a perfect way to end it here, and just want to thank everyone for attending. It's thundering outside. I'm not sure if you could hear it at my house, but it's super loud over here. I'm glad my power didn't go off, so that's a good thing. But thank you to everybody for being here. Our panel was fantastic with really great information. And I know Lindsay and Eric are very thankful as well. So yeah, we did our best to get to as many questions as possible, but please email us if there's anything we can do, even if it's not management, just for questions or referrals. We're happy to help. So you can reach us all at info@castlegroup.com, or you could throw our names in there, email away, L. Reyes, J. Esposito, if you want to get us directly. And that's it, at castlegroup.com. So again, thank you to everyone, and enjoy, stay dry.
Hope you all have a great day.
Thank
Thank you.
Thank you.
Thank you. Thank you.